Large language models are the insatiable beast of the digital wild. They roam an enormous landscape in search of food and sustenance. Their food is data, language, images, code, designs, patterns and preferences, and the accumulated intelligence of all human institutions. That hunger is not by itself sinister. It's how these systems will become useful. But if you run a business, the question is not whether AI is powerful. The question is, whose intelligence is making it powerful and who owns the value after your company contributes its knowledge by using an LLM. Every business has something the market cannot buy off the shelf. It may be a manufacturing process, a pricing model, a diagnostics method, a sales playbook, a supply chain, a body of research, or simply the judgment your team has developed over 20 years. That is your business alpha, the hard-won difference between what you know and what everybody else knows. Today, we are talking about sovereign AI, how to use AI without surrendering that alpha, how terms of use can quietly waive rights you assumed you still had, and how contracts, technical controls, and trade secrets law can work together to protect the means of your own production. This is not a call to retreat from AI. It's a call to adopt AI like an owner, not an unwitting supplier of raw material. The word sovereignty can sound geopolitical. At the enterprise and business level, it's much more practical. It means your company retains meaningful control over its data, its system, its operating logic, and the economic value produced when those assets interact with AI. To understand that, we need one other term: ontology. In ordinary terms, an ontology is the map of the business. It describes the important things in your world: customers, products, assets, risks, decisions, and the relationships among them. But a real enterprise ontology is not merely a tidy database diagram. It includes context. Which signals matter? Which exceptions are tolerated? Who has authority? What sequence produces quality? And which relationships create value? It is the living grammar of the enterprise. That is why a list of customer names is sensitive, but the method that tells you which customer to call, when to call, which risks to flag, and what offer to make may even be more valuable. The competitive advantage often lives in the links, not isolated data points. Palantir CEO Alex Karp recently framed sovereign AI as preserving enterprise alpha and the means of its own production. You don't have to adopt Palantir's products to recognize the challenge. If your AI system learns the relationships that make your business work, you need to know where those relationships are stored, who can reuse them, and whether vendors' incentives are aligned with yours. A controlled ontology, then, is not a single product. It's a governed environment. Access is limited by role and purpose. Sensitive sources are classified. Every model, connector plug, agent, downstream processor is known. Prompts and outputs follow retention rules. The business can audit what happened and leave without abandoning its knowledge behind. The immediate spark for this conversation came from Palantir's CEO Alex Karp's recent CNBC appearance and the follow-on discussion it ignited across boardrooms, tech teams, and Wall Street. Karp gave language to a concern that many executives already felt. If the AI provider earns more when we use more tokens, but has no stake in whether our business gets a real result, whose interests are actually being served? That question landed with force because it changed the discussion and the framework. The issue is whether AI is being deployed to create a measurable outcome for the enterprise, or whether the enterprise is paying for a stream of activity while its valuable alpha and ontology migrates somewhere else. Palantir's answer has been shaped by a model it built over roughly 2 decades. Data platforms designed not only to analyze and detect trends, but also to govern access, preserve data privacy, context, and house the ontology that lets an organization operate safely. It also pioneered recently the forward deployed engineers, FDEs, who work with customers inside their operational structure, helping them build an outcome before the customer is asked to scale its investment. That's a dramatically different posture from, here is a model, here are your tokens, and here's the bill for those tokens, and good luck. It is why Palantir's work has spread across enterprises and government agencies where the value of the data, consequences of an error, and the need for control are exceptionally high. The question you must ask is, are you buying an outcome or only buying access? Now, FDE and ontology are becoming fashionable words thanks to Palantir. Copycat companies can borrow the vocabulary. They cannot automatically borrow the years of engineering, security design, implementation, discipline, or alignment with customer outcomes that give those words substance. So when a provider promises an ontology, an FDE-led implementation, or a closed environment, ask the hard question, does the provider win when we win? Or is the business model simply to sell more tokens, regardless of the outcomes, and regardless of whether our alpha is protected inside the closed environment? That's the reason for this episode. AI sovereignty is the discipline of making sure the technology adds value to your institution or business without turning your unique tribal knowledge and value into somebody else's asset. A controlled ontology, then, it's not a single product. It's a governed environment. Access is limited by role and purpose. Sensitive sources are classified. Every model, connector, plugin, downstream processor, agent is known. Prompts and outputs follow retention rules. The business can audit what happened and leave without abandoning its knowledge behind. Now consider the February 2026 decision in United States v. Hepner from the Southern District Court of New York. The court considered 31 documents a criminal defendant generated through the consumer version of Anthropic's Claude after he had retained legal counsel. He used the tool on his own initiative to explore defense strategy and later shared the material with his attorneys. Judge Jed Rakoff held that the documents were not protected by attorney-client privilege or the work product doctrine. Court's reasoning matters well beyond one defendant and should be a call to remind you about click-through license agreements. The exchange was not a communication between a client and attorney, and Claude is not an attorney, so the court found no privileged human relationship between the user and the Claude platform. Second, confidentiality was missing. The court looked at Anthropic's privacy terms, including terms that allowed Anthropic to collect inputs and outputs, use the data in model training, and make disclosures in specified circumstances. Against that background, the court found no reasonable expectation that the exchange was confidential. The question is, did he read the license before he pumped all that information in? Third, the defendant created the documents on his own initiative, not at the direction of his lawyer, and the material did not reflect the attorney's mental processes when it was so created. So the attorney work product argument also failed. Here's the careful takeaway. Hepner does not hold that every use of every AI system automatically waives privilege. That involved a public consumer tier tool, particular terms, particular settings used by the client. Enterprise arrangements with no training commitments, limited retentions, access controls, and counsel-directed workflows may present materially different facts. But enterprise is not a magic word, and confidentiality alone does not automatically create privilege. The practical lesson is immediate. Companies and law firms need AI use rules. Clients and employees should know which tools are approved, what information may be entered, when counsel must supervise the workflow, and how the platform's actual terms and settings have been verified. The click to accept terms of use is now part of our legal architecture. The consumer terms of use screen can allocate risks, authorize collection, permit disclosures, limit remedies, and incorporate policies that change automatically over time. If your team accepts those terms without review, it may be accepting a result your confidentiality policy says should never occur. A second development shows the same sovereignty problem from another direction. In early July of 26, Apple filed a federal lawsuit in the Northern District of California Federal Court against OpenAI entities. and 2 former Apple employees. Apple, in its lawsuit, alleges a coordinated effort to misappropriate confidential hardware information, designs, processes, suppliers, and unreleased projects information to accelerate OpenAI's consumer device work. Among other things, Apple alleges that former personnel accessed confidential files, that recruiting interactions sought proprietary information or components, and that Apple's designs, manufacturing process, supplier relationships, and project information were put at risk. OpenAI has disputed the lawsuit and state that it has no interest in other companies' trade secrets. Whatever the outcome, the cost will be in the millions before it's resolved. Why mention it here? Because the case illustrates that AI sovereignty is not only about what a model memorizes. Valuable information can move through people, devices, recruiting, vendors, APIs, collaboration tools, and physical supply chains. Your sovereignty perimeter is socio-technical, contracts and code, but also culture, training, access, and offboarding, and preservation of evidence. And then there's Reddit, who just recently sued Anthropic, claiming theft of its consumer data scraped from the Reddit site in order to train Anthropic's models. The principal federal civil tool is the Defend Trade Secrets Act of 2016. It gives an owner a federal civil cause of action when a trade secret connected to any sort of interstate or foreign commerce has been misappropriated. Available remedies include injunctions, damages, and extraordinary circumstances, an ex parte seizure order. But the statute's not a substitute for prevention. To qualify as a trade secret, information must derive economic value from not being generally known. And the owner, you have to take reasonable steps to keep it secret. That makes AI governance evidence. Approved tool lists, access restrictions, confidentiality terms, controls, logging, and incident response may help show that the company behaved as though the information was truly secret. A trade secret is not just valuable, it must be treated as a secret to remain valuable. In our last section today, we're going to discuss what you, as the emerging business owner, can do to protect yourself. So what should an AI sovereignty agreement actually do? The exact drafting depends on the use case, the data, the provider, and your leverage. But every serious review should answer 7 questions. What data is being protected? Define your customer data broadly enough to cover prompts, uploaded files, retrieval sources, embeddings, fine-tuning data outputs, feedback, telemetry, use logs, metadata, and any inferences or profiles derived from them. If definition protects only personal data, it may miss the business logic you care most about. Secondly, what may the provider do with the data? Limit the processing to delivering and securing contracted service. Include an explicit no training, no model improvement rule for your data unless you knowingly opt in through a separate specific authorization with an address aggregated, de-identified, and anonymized data directly. Otherwise, a broad analytics exception may swallow the rule. Prohibit the sale, advertising use, competitive benchmarking, and development of customer-specific substitutes. Do not stop with the front-end vendor. Require the same restrictions for sub-processors, model providers, plugins, agents, and hosting partners. The provider should remain responsible for their compliance and give notice before materially changing that chain. Number 3, who owns the inputs, outputs, and improvements? The agreement should confirm your ownership of inputs and allocate rights and inputs to you to the fullest extent permitted by law. It should also separate your materials from the provider's pre-existing technology. Pay attention to the adapters, embedding, tuned weights, prompts, evaluation sets, workflows, and feedback. Those are often where your operating logic accumulates. Remember that contract ownership language cannot manufacture copyright where copyright law does not recognize it, and it cannot guarantee that output is unique. What it can do is allocate the parties' contractual rights, duties, and risk. Number 4, how long are they going to retain the data and where? No training is not the same as no retention. A provider may promise not to train on your content while retaining prompts and outputs for safety review, abuse monitoring, debugging, backups, or legal compliance. Define retention periods for every copy and log. For the most sensitive workflows, you need to require zero data retention where technically available and compatible with the feature set. Also, specify approved processing locations, backup locations, encryption expectations, key controls where appropriate, and procedures for government or third-party demands. A data residency promise is useful, but it's not complete sovereignty if administrators, subprocessors, or legal regimes can still reach the data. Number 5, how do you verify the promise? Require documentation proportionate to risk, architecture and data flow diagrams, an inventory of models, connectors, and subprocessors, independent reports such as SOC2 Type 2, penetration, test summaries, incident history, and a whole raft of other items. At minimum, demand visibility into the components and dependencies that touch your environment and the provenance controls relevant to your risk. Audit rights should be usable, not theatrical. State the frequency, scope, evidence, remediation deadlines, and who pays when a material deficiency is found. What happens when something goes wrong? That's number 6. Require prompt notice of an incident, preservation of evidence, containment, root cause analysis, cooperation, and a written remediation plan. For unauthorized training or model improvement, negotiate deletion of source data, isolation of affected artifacts, cessation of use, and technically feasible remediation of derivatives or model influence. Algorithmic disgorgement is a useful negotiating concept, but the remedy must be defined precisely. Complete machine unlearning may be technically difficult or impossible. Review indemnities and liability limits for confidentiality breaches, secure incidents, IP claims, unlawful data use, and agentic actions. A low fee-based cap may bear no relationship to the value of the exposed ontology. Consider a higher supercap or uncapped treatment for the risk that can destroy the asset you're trying to protect. Last, can you leave with your knowledge intact? Require export in a documented, usable format, transition assistance, continued access for a defined period, deletion from active systems and backups on a stated schedule, and certification of destruction. Address fine-tuned artifacts and configurations before deployment, not at termination. Sovereignty includes a credible exit. I'm not an engineer, and there's a lot of technology involved in protecting your data, but it does have to be put in a written contract, which does involve your legal team or your attorney. So the purpose of this is to direct your awareness to what the risks are and to take seriously what it requires to protect your data when embarking upon a large and perhaps business-changing AI project. Technical work matters enormously, but it belongs in the implementation guide, not in a rapid-fire podcast checklist. There's a download you can have that accompanies this episode, and it walks your legal, security, technology, and procurement teams through the specific questions around data flows, retention, access, vendor verification, and exit planning. The point for today is simple. The contract and the system must tell the same story. A vendor promise is only meaningful when the implementation can support it and your team can verify it. The AI revolution is already here. The question is whether it will compound your advantage or quietly steal it. Your enterprise is more than its files. It's the relationships among the people, the data, decisions, and processes, the ontology that makes the institution itself. Protecting that ontology does not mean refusing innovation. That's not an option, as you may well be left behind. But designing the legal and technical boundaries that allow innovation to happen on your terms while protecting valuable intellectual property is vital. Remember the 3 warnings from today. Will your business and enterprise alpha feed the beast and train your competitors? 2, Hepner tells us that the infamous click licenses and consumer LLMs waive legal rights, confidentiality, and access to any data uploaded. While enterprise-level offerings purportedly offer safeguards, which are contract terms, While enterprise-level offerings purportedly offer safeguards, which contract terms are important to include as a backdrop if the beast ingests your data in violation of any agreement to the contrary. Apple's newly filed case reminds us that trade secrets move through human and technical systems, and that litigation is costly, even when powerful remedies exist. And the DTSA reminds us that if we want the law to recognize something as a trade secret, we must take reasonable measures to keep it secret. Before you deploy the next AI tool, ask, what is this system learning about my business? Who can use that learning? Can we verify the answer? And can we exit with our tribal knowledge, our rights, and our competitive advantage intact? I've created a sovereign stack chess list for your legal, technical, security, and procurement teams. It contains the detailed technical questions and data retention considerations, as well as implementation controls that we are intentionally keeping out of this episode. Protect your alpha. Build AI that works for your business without consuming your business. And join the brand revolution. Thanks for listening, and I'll see you on the next episode.